In the Gospel of Matthew, Jesus Christ called Christians to a stronger kind of marriage rooted in Genesis, where men and women were joined together in a truly lifelong bond. Jesus said, "Because of the hardness of your hearts, Moses allowed you to divorce your wives, but from the beginning it was not so. I say to you, whoever divorces his wife, unless the marriage is unlawful, and marries another, commits adultery." His apostles were left astounded by the difficulty of what was being proposed, and they said to him, "If that is the case of a man with his wife, it is better not to marry." The disciples correctly recognized that Jesus is calling Christians to a far more difficult way than the practices of either the Jews or the pagans. It was a turn toward the perfection of the original state of the Garden of Eden. But even though Christian marriages ask more of a Christian than marriage asks of a secular person, it is also a much greater good than a secular marriage, because Christian marriage is an image of the love of Jesus for his church, and is a sacrament endowed by God with special graces that enable the follower of Christ to love like Christ loves. Through the centuries since Christ's earthly ministry, the Catholic Church has safeguarded this understanding of marriage, and retained its indissoluble character against the rupture of the Eastern Orthodox, the laxity of the Anglicans, and the emergence of ever broader divorce laws throughout the Western world. The Church defends Christ's understanding of marriage because the family is an essential building block of society. As the Catechism says, the family serves as the foundations for freedom, security, and fraternity within society. But a Christian marriage is also an image of Christ and his Church, and just as Christ will never revoke his covenant with his Church, neither can the Church permit a husband or a wife to erase their covenant with one another. As the Code of Canon Law says, a valid matrimonial contract cannot exist between the baptized without it being, by that fact, a sacrament. If the Church sees Christ's teaching on marriage as truly ironclad, then what is an annulment in the Catholic view? Put simply, an annulment is an investigation by the Church's canon lawyers and a marriage tribunal into the specifics of a couple's union to see whether the immaterial bond of holy matrimony was truly formed. As Christ's own words say, "Whoever divorces his wife, unless the marriage is unlawful, and marries another, commits adultery." The way the Church understands this verse is that when there is an unlawful marriage, in the Greek porneia, this unlawful marriage refers to a union where the marriage bond itself is never formed, but only appears to be formed. But if all marriage bonds are invisible, then how can the Church determine whether it really exists? And what is the meaningful difference between an annulment and a divorce? Although it is of course true that only a couple who were seeking to separate would pursue an annulment in the first place, what the annulment process rules on is not the present desire of the couple, whether they want to be married or not, but the situation at the time of their original wedding ceremony. And it is this objective reality that is the basis for determining whether the annulment is granted, and not the preference of the couple. While civil divorce may separate a couple legally, and may even be a prerequisite to the annulment process, this civil process has no effect on the marriage bond itself. Generally speaking, the Church presumes that a marriage has been contracted validly unless the marriage tribunal has shown otherwise. As the Code of Canon Law notes, marriage possesses the favor of law. Therefore, in a case of doubt, the validity of a marriage must be upheld until the contrary is proven. When diocesan professionals, like canon lawyers, investigate the marriage bond, they do so by looking at the details of the original union, at the mental faculties of the couple, at their understanding of what they were agreeing to, at the form that was used, or at details like whether one or both of the parties were previously married. Ideally, these sorts of things are already worked out and clarified with a priest before a couple agrees to a marriage ceremony. But in cases where the couple failed to get married through a Catholic service, had mistaken knowledge about the sacramental life, were ignorant of some important detail regarding each other, or were misled or manipulated in some way that would have caused the marriage bond to fail, the nullity process exists to clarify the situation. Though canon law can be complicated and require years of study, the reasons why a union may fail to result in marriage are able to be understood at least at a surface level. A marriage exists as an indissoluble union formed by the consent of a man and a woman, ordered first and foremost to the procreation of offspring, and secondarily for the good of the husband and the wife. This understanding of what a marriage is becomes the lens by which every cause for a declaration of nullity is established. For instance, the marriage could be invalid if the couple agreed to a union but refused to be open to children, and intended to contracept for the rest of their lives. This would be a violation of one of the core principles of marriage, which is openness to life. Likewise, if one or both parties were unable to engage in intercourse through psychological hang-up or physical limitation, they would be unable to fulfill the unitive end of marriage, which would make forming a marriage bond impossible. It is, however, worth noting here that, as Canon 1084 notes, being sterile is not an impediment to marriage, because couples are not obliged to fulfill certain outcomes like children, but only to be open to them, and not to oppose the normal functioning of the sexual act. Other causes for invalidity can be related to factors which are separate from the essentials of the marriage bond as such, but are still important for a matrimonial contract. For example, forcing the other party into marriage, lying about some important personal detail, consanguinity, which is when individuals are too closely related by blood to be married, affinity, such as trying to marry your sister-in-law or the daughter of your godfather, being underage, which is 16 for men and 14 for women, disparity of cults, where one party is baptized but the other isn't, or mixed marriages, where one party is Catholic while the other is Protestant, Orthodox, or some other kind of Christian. While some of these causes for invalidity are perpetual and always bind in all cases, some causes of invalidity can be dispensed by the power of a bishop, if the couple seeks out this dispensation before the marriage actually takes place. The bishop has this power because, even though marriages are spiritual bonds which are conferred by the couple upon one another, Christians are still governed by the power given to the Church by Christ. As the Ecumenical Council of Trent notes, this power has ever been in the Church that, in the dispensation of the sacraments, their substance being untouched, it may ordain or change what things soever it may judge most expedient for the profit of those who receive. Flowing from this principle, the Church can set up or remove prescriptions around the sacraments to safeguard them from abuse. An example of a marital dispensation from Canon Law is when the bishop, following Canon 1124 on mixed marriages, dispenses the canon preventing a Catholic and a Protestant from becoming married on the condition that the children are raised in the Church, in which case the good of the offspring is secured, and the ultimate effect of the marriage bond is preserved. However, if the couple get married outside the Church, through a civil ceremony, or without getting the proper dispensation, their marriage is invalid. When someone seeks separation through the Church, the first step is to contact the correct diocese, likely the one in which the marriage took place, or where a person currently lives. The party who is petitioning for the union to be examined must complete a document called a libellus, which is a formal document with details about which specific reasons the Church should declare a marriage null. As detailed in Canon 1676, where possible, reconciliation is the preference of the Church, and the reformation of a true lifelong bond. But if this fails, and the case is accepted by the diocese, the couple will go through the nullity process, a process which shares many similarities with civil law. The nullity process is decided by an ecclesiastical tribunal. During the tribunal, an advocate may be assigned to represent a petitioner who has presented the libellus, and another advocate for the respondent who may disagree that their marriage is invalid. Advocates represent their clients not unlike a civil lawyer, though there may be only one advocate if the couple agree on the details of the case. During the tribunal, the facts of the couple's case will be presented and an argument is made based on which part of canon law in particular could cause the marriage to be invalid. There will also be a defender of the bond who acts similar to a state prosecutor, except his job is to prove the contrary of the nullity case, or in other words, he is supposed to convict the couple of really being married. There may also be the role of the promoter of justice, who is similar to a district attorney acting on behalf of the Church and the public good, and is especially concerned with nullity cases that overlap with penal cases, or cases having to do with public order. In these situations, he may bring the nullity case before the tribunal himself rather than the petitioner, if, for example, the petitioner were in prison. To authenticate the proceedings in general, the tribunal is witnessed by the role of a notary, whose role is so essential that the trial fails if the notary does not verify the acts. One or more judges will preside over the case, and this judge will hear the evidence of witnesses and experts who bear upon the specific marriage case at hand, making decisions about the process of the case. The judge's role is occupied by default by clerics who are trained in canon law, though bishops' conferences may permit similarly well-schooled laypersons to also serve in this function. These judges act with the power of the bishop, or else the bishop himself may serve as a judge, particularly in cases of an expedited nullity tribunal, so as to avoid any error about the decision. After all the necessary legal proceedings, there will follow the judgment of the judge once he has reached moral certitude about whether the annulment should be granted. Should the parties involved disagree about the outcome, including the defender of the bond, they can appeal the decision of the judge, even up to a higher court in Rome itself. But once the matter has been decided, at whatever level of jurisdiction settles the matter, the parties must abide by the decision even if it turns out that the ecclesiastical courts have determined that the parties are still married in the eyes of the Church, in which case neither the bride or groom would be free to form a new bond since their existing bond remains intact. But if annulment is granted, the Church has determined that the couple never had a sacramental bond, and are generally free to form a new bond of marriage with a new person, provided the original reasons for the annulment would not still apply in the case of this new attempt at marriage. I hope you have found this video simplifying the annulment topic to be informative, and that it has clarified the ways in which this practice is distinct from divorce and the reasons behind these differences. If you want to dive further into the theology of annulment versus divorce, please see my previous video on Catholic versus Orthodox understandings of this topic.